Welcome to Indiana News Desk. I'm Joe Wren. Is Indiana meeting its constitutional obligation to provide fair and speedy trials for Hoosiers regardless of their income? It's a question we started to examine in part one of our series, Justice for All, last week. Barbara Brosier has spent months looking into this issue. Barbara, this is a question the courts are considering.
Well, that's right, Joe. We've told you about a class action lawsuit challenging the adequacy of Johnson County's public defense system. Well, a lawsuit filed at the federal level makes similar claims about Allen County. People there say the public defense system is constitutionally, structurally, and systematically deficient. And a national advocacy group for the indigent says it's a problem that spans the state.
The liberty that we cherish so much and enjoy, really, it is dangling by a slender thread.
They work for the state. Their caseload is way too high for them to give any adequate representation to anyone.
Public defense systems in so many of the states around the country, including Indiana, I fear, is failing.
If you get arrested, your odds of getting an independent lawyer are extremely slim.
Asia Marshall thought she was on the path to success.
I've never been in trouble. I worked for community corrections. I have a bachelor's degree in criminal justice and an associate's in human services.
The single mother worked hard to get an education and start a career so she could not only provide for her family, but also serve as a role model.
I purchased a house at 30 in Arlington Park. I mean, I had high standards and I was on a path of high, moving up, motivated.
But her path drastically changed in December 2014.
I was arrested for domestic battery, misdemeanor.
According to court documents, Marshall's boyfriend at the time called 911, claiming she hit him in the face with a remote, causing him to bleed. When police arrived, he told them he didn't want Marshall arrested. But still, she was taken into custody and charged with domestic battery and disorderly conduct. Marshall maintains her innocence and fought the charges for a couple of months with the help of a private attorney. When she ran out of money, a judge assigned her case a public defender. And that's when Marshall says the problems started.
I was provided on June 29th a defenseless trial.
A jury convicted Marshall of both charges. It was her son's birthday, and she was sent off to jail.
We had his party scheduled for Jungle George's, had him a nice cake and everything.
Because of what happened at her trial, Marshall is part of a class action lawsuit that alleges Allen County's public defense system is inadequate. The lawsuit says her public defender called no witnesses, introduced no evidence, and refused to let her testify during the trial. Marshall says she was repeatedly pressured to take a plea deal, but she refused because she says she's innocent.
To me, they're plea pushers. It's easy to push a plea. I don't have to research this case. I just make this sweetness deal and make this sound good from a person. The average person does not want to fight.
Attorney David Frank is representing the class action lawsuit against Allen County. He says some of the public defenders here have been assigned as many as 4 times the maximum number of misdemeanor cases allowed by state standards. The lawsuit claims, as a result, the part-time public defenders can't devote the necessary time to most cases.
It's embarrassment to the state, but more importantly, it's causing the incarceration, the needless incarceration, and devastation of lives of the poor. And somehow no one wants to talk about that. That's the population being affected.
An Indiana University McKinney School of Law professor recently penned an expert report supporting the claims in the lawsuit. He writes the caseloads in Allen County are, in his words, much too high and therefore pose an unacceptably high risk that many of the clients represented by these lawyers will not receive reasonably effective assistance of counsel.
They are really asked to provide representation in circumstances where they don't have the resources, they don't have adequate compensation, and they so often have truly outrageous caseloads. And as a result, they wind up practicing law in ways that they would never do if their client had adequate financial resources to provide compensation and to pay for the auxiliary support services that are necessary in public defense.
Allen County does participate in the reimbursement program through the Indiana Public Defender Commission, which means it has to comply with training and caseload requirements. But the rules only apply in felony cases. So in misdemeanor cases like Marshall's, there's essentially no way to hold counties accountable for the quality of public defense they provide.
If you have a county that is theoretically constitutionally obligated to provide a service to poor people, but if they don't, there's no consequences, what do you think a county is going to do? They're not going to do anything because they don't have to.
That was one of the top findings in a report by the Sixth Amendment Center, a national nonpartisan group that advocates for the indigent.
There's a lot of collateral consequences that come from a conviction on a misdemeanor, and yet counties and cities are not held to any sort of standards, and for the most part, they're providing services by contracting with a single attorney or a group of attorneys to handle an unlimited number of cases. These attorneys spend very little time on these cases, and people are ending up with very serious life consequences because of it.
The report says outrageously high caseloads for public defenders are a problem throughout the state. It says in 2014, some Elkhart County public defenders had as many as 5 times the maximum allowed cases in a year. That same year in Marion County, one attorney had a caseload that was more than 3 times the cap.
And the program needs to be adequately funded with the general revenues of the state.
Those statistics led several attorneys to file a petition last year asking the Indiana Supreme Court to spell out rules, procedures, and standards for defending the state's indigent. And it asked the court to establish a statewide public defender system.
Indiana is at the lower half of the 50 states. So you take a state like Louisiana, where people may have been reading about all the indigent defense problems there and people going without counsel. Well, Louisiana currently spends $66 million a year on indigent defense, and they have less of a population than Indiana.
The financial resources overall that are provided in Indiana for public defense services are simply inadequate. And you cannot have a first-class system of public defense unless you have the appropriate structures in place to assure that the defense representation that is provided is both competent and effective.
The state Supreme Court hasn't acted on that petition for rulemaking. As for Asia Marshall's criminal case, the Court of Appeals recently vacated her disorderly conduct charge, saying she was being prosecuted twice for the same offense, but her domestic battery conviction still stands. The Indiana Supreme Court declined to hear that case.
All right, thank you very much, Barbara. And next week, we'll take you to Kentucky, where there is a statewide public defense system in place.